Welcome to the Republican Professor. I'm your host, Dr. Lucas J. Mather. Today is Friday, 22 May, 2026 years after Jesus. Welcome back. We're in constitutional law again today on private property. Possession and use is the topic. Possession and use. We started this series last year, 2025, celebrating the 40th anniversary of Harvard University Press's Takings, Private Property and the Power of Eminent Domain by Richard Epstein. No relation to Jeffrey. And we'd like to thank Harvard University Press for making this material available. We'd like to thank Richard Epstein for writing it. We're going to do a fair use and make a transformative reading of this material. We're going to discuss it. We're discussing chapter 6 today. How fun! Possession and use. And this is what it looks like. I would suggest you get a physical copy, one that you can hold in your hands. And then when you're done holding it in your hands and cradling like a little baby, you can put it back on your bookshelf and invite people over for dinner just so they can look at your books and be impressed and go, dang. Um, and then, I mean, who cares whether you like them or not, but it always helps if you like them. Anyway, Richard Epstein at the time was James Parker Hall Professor of Law at the University of Chicago, which I looked that up and I think it's in Chicago. I'm pretty sure it's the same city. We left off our 10th episode on this series, ending at page 62. And so we're on page 63, possession and use. The section title is Takings Prima Facie still. So we have, I think, two more in Takings Prima Facie, right? Maybe three more. Let me look. Let me look. Chapter 8. Oh, chapter 8 is in Takings Prima Facie too. Okay, so 6, 7, and 8. Then part 3 is justification for takings. And that's when we get into the police power theories, which is really, really important foundational stuff. Okay, so we're not going to get too far ahead of ourselves. Let's get into this. And again, get your physical copy today. Go to Harvard University Press and throw some money their way. Get this copy, get it used, support your local book dealer. Somebody that we had on the podcast, Columbia law professor Philip Hamburger, came on the podcast. His books are excellent, and they are published generally by Harvard University Press. So if you're in the Harvard University Press catalog, make sure you check out Philip Hamburger's selections. And he teaches at Columbia Law, which is in, I think it's in Nova Scotia. No, just kidding. It's in New York City. All right, let's go. Possession and use, chapter 6. The notion of exclusive possession, which is implicit in the basic conception of private property, accounts for one of the most important takings cases in the Supreme Court literature, Pennsylvania Coal Company versus Mahone. There, the owner of land containing coal deposits deeded the surface interest but expressly reserved the rights to remove all the coal underneath the surface. The deed itself contained language by which the buyers, for themselves and their assigns, waived all rights to damage in the event that the surface fell. Sometime after the original conveyance, Pennsylvania passed the Kohler Act, which forbade any mining that caused damage to the surface owner. The Supreme Court held the statute as a taking, of the mining company's interest, which it clearly is. The case itself contains elaborate language by Holmes, which he later regretted in correspondence, that where regulation goes, quote, too far, and I have in the in the margin LOL unquote, it will be treated as a taking for which compensation must be paid. Owing to the clarity of the grant, however, the case is an easy one. Before the statute, the coal company was in possession of a mineral estate. After the statute was passed, the interest itself was lost. Hold on. Let me look at footnote 2, Holmes, the Holmes quote. It's in Bruce Ackerman, Private Property in the Constitution. The letter below. Oh, no, sorry. The letter is belies an assertion in Bruce Ackerman. That's interesting. Okay, I'm going to say this. Footnote 2, bottom page 63. Richard Epstein says, if you look into it, do a little digging. He says the opinion by Holmes shows all the signs of having been dashed off in a great hurry. Yeah, yeah. Poor Holmes. I guess he admitted as much to Frederick Pollock. Oh, those are in the archives. Okay. Quote, if the city's representatives have been so short-sighted as to acquire only surface rights without the right of support, we see no more authority for supplying the latter without compensation than there was for taking the right away in the first place and refusing to pay for it because the public wanted it very much. All else is superfluous. The case is easy, although the opinion has generated an enormous amount of scholarship. Wow, that is so funny. I have LOL in the margin. Wow. Okay. Because the public wanted it very much. Yeah, that's you lose your property rights because somebody wants your property. Wow, man. Oh, geez. Other more recent cases of equal ease, however, indicate how the Supreme Court has been able to escape this simple conclusion. In Penn Central Transportation Company versus City of New York, the issue before the court was whether the City of New York, acting pursuant to its landmark preservation statute, was entitled to prevent the owners of Grand Central Terminal from constructing a new office tower over the current structure. Here, there is no question about remote reaches of the ad caelum doctrine because the owners claimed the right to occupy only airspace that could be effectively occupied. The Supreme Court, however, decided that so long as the use of the existing structures was not impaired, the city could wholly prohibit the occupation and use of the airspace without payment of compensation. The court, speaking through Justice Brennan, held that the state may exclude persons from the occupation of part of what they own and still not come under a prima facie obligation to pay compensation. It it did attempt to dress up this bald assertion with a contention that it was a fallacy to to assume that the loss of any particular right of easement constituted a taking of property. Oh man, man. But the so-called fallacy is really an affirmation of the standard conceptions of property applied everywhere and all at all times in the United States. Ownership is divisible. Air rights over the existing building were property just as much as Air rights already occupied by the existing structure. Justification and implicit compensation are still matters to be considered, but the case is clearly caught by the clause. This is great. One thing I love about Richard, and I've said this like probably this is the 11th episode. I think I've said this every single episode that his writing is sometimes a bit sparse, but you can't complain. It just you don't really need to say anything else. He says it. Now, and that I love that phrase caught by the clause. That's great. Okay, bottom page 64. A similar treatment of the right of exclusive possession is found in the more recent Supreme Court case of Prune Yard Shopping Center versus Robbins. Now, let me take a look at the footnotes here. Okay, the footnotes are great, but I'm going to skip those footnotes. Page 65 at the top. There are appellees entered there. The appellees entered a large shopping center owned by the appellants and erected a booth in order to collect signatures in opposition to an anti-Zionist resolution passed by the United Nations. There was no interference apart from the fact of partial occupation with the business of the shopping center, but the views endorsed by the appellees were not the views of the owners of the shopping center. Mm. The Rehnquist opinion reveals its intellectual weakness at every turn. Notice here, and this is really good for you to notice. It's a big picture item that I think would be very good for you to drill into your noggin here. Okay. Um, he doesn't hesitate to criticize the high court. Majority opinion, it doesn't matter if it's majority or dissent. You know, the opinion is binding in that case, but he's going after them. And he's like, you could have done better, you should have. This is bad. It's not good. It's and we're going to discover why it's not good. That's the whole point of writing this book. If whatever the highest court or the ultimate resolution of a particular case was always the right answer, then there'd be no reason to have books like this, right? You would just read the opinions and then just go, okay, yes, Daddy, thank you for telling me what was the right answer. What Richard is trying to get you to do is to think for yourself. Think for yourself. That's going to require you to grow up into maturity. Okay, let's keep going. I think you get what I'm saying. So the Rehnquist opinion reveals its intellectual weakness at every turn. Nowhere does the court offer a coherent account of the incidence of ownership. Wow. Tell us what you really think, Richard. Nowhere does the court offer a coherent account. Man, that is a devastating criticism of the incidence of ownership, including exclusive possession. In private cases, no injunction against entry is dependent upon showing actual damages. The entry itself is the violation of the right for which the injunction is available for redress, even if no damages can or should be awarded. It therefore follows that any demonstration about the negligible impairment of the appellant's rights is wholly beside the point, just as it would be in a private dispute. The entire matter of investment-backed expectations does not go to the taking issue as much as such. It only goes to the issue of reliance damages when, as, and if relevant. It is well and good to note that the shopping center is not a private home and that the invitations had been issued to many to come onto the land for many purposes. That is all quite irrelevant. The idea of property embraces the absolute right to exclude. Whatever the status of others, there is no invitation to these plaintiffs. The Lockean theory controls. No private person could force his way into the shopping center without the consent of its owners. Nothing, therefore, allows the state to place conditions upon the owner's right to admit or exclude, or to insist that if A is admitted to the property, then B must be admitted as well. The restrictions that the state places upon the exclusive possession of the land, excuse me, the restrictions that the state places upon the exclusive possession of land constitute a partial taking for which compensation is prima facie required. Justice Marshall had some sense of the intellectual problem when he noted that some normative conception has to underlie the constitutional interpretation of private property. Excellent. Excellent. There we go. This is excellent. The natural law comes in. From a Christian perspective, natural law is the reality of moral obligation and moral descriptions, true descriptions of right and wrong, good and bad, virtuous and vicious, a bad and good character, action, all that. Okay? And what he's saying is Justice Marshall. Who's Justice Marshall? Justice Marshall had some sense of the intellectual problem when he noted that some normative Justice Marshall is a guy in the Rehnquist in attached to this Rehnquist opinion he's talking about. Okay, so if you look that up, let's see here. It would be I'll look it up for you. I think it's I'm gonna have to look this up here. The Rehnquist opinion. I'll cite the case for you. I'll pause it and I'll get it to you. Okay, so the Rehnquist opinion reveals its intellectual weakness at every turn. Then, okay, go down. Justice Marshall had some sense of the intellectual problem when he noted that some normative conception has to underlie the constitutional interpretation of private property. That's absolutely correct. Lest a constitutional command be defeated by perpetual legislative redefinition of its subject matter. Yet his mistaken concurrence offered no such alternative construct that would allow him to respect the external authority of the constitutional text and decide this case in favor of the demonstrators. That's really good. I am not quarreling with the importance of the First Amendment's political guarantees. Yes, good. But it is mistaken to argue that the exercise of this freedom, unlike the exercise of any other freedom, gives the appellee the right to appropriate the land. Okay, page 66 at the top. The land of another for his own use any more than the First Amendment gives a political candidate the right to use his neighbor's telephone free of charge. Wonderful. Wonderful. You guys know what a telephone is? You ever heard of that? The phone used to ring and we used to run over to it, it was on the wall and we'd grab it. We didn't even know who was calling. We were so curious to see who was calling that we would answer it. Most of the time we would go run and go answer it. Now The phone rings, it's in your pocket, and allegedly we can get a hold of you any time of day, any time of day. And then you look and you can see who's calling, right? Well, then you just say, I'm not going to answer that, I guess. Pretty sad. Human nature, man. Okay. If prune yard represents the best that can be done for private property, then an artful judge of a different persuasion could, with perfect probity, interpret the First Amendment as nothing more than a solemn guarantee of the right to exchange social pleasantries with close family friends, but not, of course, on private property. Freedom of speech gives one the right to talk in ways that are unpleasant to others without any justification for doing so. So, private property gives the right to exclude others without the need for any justification. Indeed, it is the ability to act at will and without need for justification within some domain, which is the essence of freedom, be it of speech or property. Okay, the next section is use, page 66. The treatment of the incident of use follows a parallel line. The early decisions in Pompelli, Eaton, and Richards are best understood as vindications of the constitutional rights to use property in connection with certain forms of tortious invasions, patterned on theories similar to that of Rylands versus Fletcher. Rylands versus Fletcher, 1868. The errors in Batten, and that was discussed in chapter 4, are likewise easily understood as the court's refusal to protect the incident of use as separate from both possession and disposition against interference by nuisances. Remember we talked about nuisances and how, well, go back to that episode a couple of episodes ago, talked about nuisances. Now, all those cases involve easements, but the same point can be made in connection with government actions to impose restrictions on use that in private contexts could be imposed by covenant. If the state, as owner of a large office building, prevents by law all construction on land that lies between the building and the ocean, it has taken an interest in private property. Again, a powerful theory of private rights, here of restrictive covenants, governs the situation. That the government has not taken physical possession of the land is neither here nor there. It clearly will enter the land by force if the covenant it has created by fiat is not respected by the parties who are subject to it. The government's position is unique only in that it can force exchanges where private defendants could be enjoined. But whether we deal with total or with partial interests in land, we cannot avoid the compensation requirement when the owner is deprived of rights. Page 67 at the top. How are you enjoying this? I'm really enjoying this. Let's take a look at some of the stuff on the back matter here. Laissez-faire Books says it's a dazzling book filled with brilliant insights and powerful arguments that promise to reshape our thinking in political philosophy. The Freeman says, remember, this is published by Harvard University Press. I guess they might say they made a mistake. I don't know. But it says this, the Freeman says this brilliant new book has the intriguing thesis that the eminent domain or takings clause of the United States Constitution, properly understood, provides clear limits to government power, protects private property, and forbids any legislation that has the effect of redistributing wealth. It would be hard to overestimate its importance. The Wall Street Journal says takings makes a fascinating case that the New Deal is simply unconstitutional. Fantastic summary right there. I gotta say that again. Takings makes a fascinating case that the New Deal is simply unconstitutional. Yes, absolutely. Takings, private property in the power of eminent domain by Richard A. Epstein. We got another quote, one final one. This is from National Review. Epstein combines legal scholarship and libertarian conviction to produce a brief against the destruction of property rights in modern America, a refreshing challenge to most conventional defenses of the welfare state. Fantastic. Yeah. All right, great. Keep going. Now, we're on page 67, possession and use water rights. You've never been more excited. The analysis of the rights to possession and use has thus far referred only to land. The analysis can be extended with equal force to water rights cases. The rights in question are, in riparian jurisdictions, typically incident to the owners of the riverbanks or shore. The loss of these rights, therefore, is best understood as a partial taking of a larger interest in private property. In water cases, the fresh obstacle stems from the obvious but important point that the initial distribution of rights in and over water cannot be specified as precisely as for ordinary real estate or chattels. Yet some account of those property rights is needed to determine whether certain state activities constitute, in whole or in part, a taking of private property, or whether, in the alternative, they work to the disadvantage of the aggrieved party without infringing upon any vested rights. To note the necessity for an account of original entitlements over water is not to provide such an account, a point forcefully made in the well-known passage from Justice Jackson's opinion. That's Robert Jackson, FYI. By the way, never graduated from law school. He's the last Supreme Court justice that never graduated from law school. Very fascinating guy. Former Attorney General under FDR. Well-known passage from Justice Jackson's opinion in the United States versus Willow River Power Company, 1945, where dam construction resulted in the loss of generating power from a headwater. Okay, so Jackson wrote, and this is a block quote, "It is clear, of course, that a headwater has value and that the company has an economic interest in keeping the St. Croix, the river blocked up uh, in the case, at the lower level, but not all economic interests are property rights. Only those economic advantages are rights which have the law back of them. And only when they are so recognized may courts compel others to forbear from interfering with them or to compensate for their invasion." Okay. Now, that's an unquote. The first proposition, that it is necessary to distinguish between entitlements and advantages, cannot be denied. But the second proposition, that advantage becomes an entitlement only when the court says it is, does not follow from the first. Very good. The second proposition is, in fact, both incorrect and inconsistent with the eminent domain clause. I have LOL in the I'm giving you my commentary. My commentary was simply LOL. Uh, Although the clause does not contain a definition of private property for water rights, when he says the clause, he's talking about the eminent domain clause, like the title, the whole point of the book, you know, just just in case some of you guys are your eyes are crossed and your eyes are glazed over. I don't know, but I mean, I think this is fascinating. Maybe maybe you're bored as hell. I don't know, or bored as purgatory, as the case may be. The second proposition is in fact both incorrect and inconsistent with the eminent domain clause. Although the clause does not contain a definition of private property for water rights, it demands that we isolate some independent normative account. Hmm. Yes, that's right. That's exactly right. In addressing this task, the Supreme Court has given far too, okay, page 68 at the top, much weight to the navigation servitude, which is said to be both paramount and superior to all the riparian interests with which it conflicts. The dubious pedigree of navigation servitude should be apparent from its supposed origins in the Commerce Clause. Yet to assert that navigation servitude is paramount is to confuse a grant of jurisdiction, however broad, to the federal sovereign with ownership of things within that jurisdiction. The Supreme Court itself has recognized that the Commerce Clause speaks in terms of power, not of property. Mm. Yet all that is taken back in the next sentence, all that is taken back in the next sentence. But the power is a dominant one which can be asserted to the exclusion of any competing or conflicting one. The power is a privilege which we have called a dominant servitude or superior navigation easement. Once this elementary confusion of jurisdiction with entitlement is exposed, how then are the initial entitlements determined? Here, the central insight is that which organizes the entire discussion of prima facie takings. The government is not vested ipso facto with any rights at all. The most important sentence in this entire chapter. And again, the entire chapter is possession and use. It's in the section called Takings Prima Facie. Once again, takings, private property and the power of eminent domain by Richard Epstein. He's the co-host of Law Talk. Fascinating. I think it was with Stanford. Now it's with UT Austin with John Yoo. John Yoo, of course, Berkeley professor of constitutional law. Came on the podcast. He was one of the first guys that we had on the podcast. John Yoo. He's great. I love that guy. When I asked him on the podcast, he responded immediately. Immediately. And he said any friend of Mike Ullman is a friend of mine, so he'd be happy to do it. And he came on, generously gave us his time to talk about Trump and the law of presidential power. That was 2022. So Richard Epstein is on this Law Talk podcast with John Yoo, and he also does the Libertarian too, which is also an excellent one. The Libertarian, the only thing I don't like about that one is they don't publish all of their past episodes, which really annoys me. But it's really good. It's really good. The Libertarian. So I would say you check out both of those podcasts and let me know what you think of them in the comments. Yeah, I think it's wonderful. All right. So I'm going to repeat that important sentence. The government is not vested ipso facto with any rights at all. So good. Once this elementary confusion of jurisdiction with entitlement is exposed, how then are initial entitlements determined? Here, the central insight is that which organizes the entire discussion of prima facie takings. The government is not vested ipso facto with any rights at all. It's pretty basic, man. It's pretty basic. It is only vested with the rights it derives from the individuals it represents. That basic lesson is so important for so many different realms. Far from allowing an ad hoc cleavage between public and private law, it insists on their intimate connection in water law cases as elsewhere. In order to find the appropriate baseline for judgment, therefore, it is necessary to sort out the original entitlements over water between private parties. Some cases seem more or less straightforward because the happenstance of a dispute over water rights does not complicate the specification of original position. Thus, in Kaiser Aetna versus United States, that would be 1979, the private party at its own expense converted a non-navigable a non-navigable body into navigable waters. Even though the company took all the steps to keep the waters private, the government asserted that its paramount easement extended to them. The claim was rejected on the simple ground that it was difficult, if not impossible, to infer a transfer from private to United States control solely from the private development for private gain. A private dirt road does not vest in the government once it has been paved. That's really good. So he's giving a riparian analogy with roads. That's really nice. I like that. Now, if the law says that anyone who paves thereby opens his road to public use, there is a partial taking, as a use that was once absolute is now made conditional. That's very good. He is so dead on this, guys. I'm hoping you're taking this in. So too with water rights. Man, he's pushing back on. Okay, so a recent set of disputes like Sackett versus EPA. Just look at that 2009. Sackett versus EPA. When was that decided? Why did I say 2009 so quickly? Well, I think there's been different iterations of it. You want to look at Sackett versus EPA, and I'm going to have to, you might have to sort through some options there, but different years. But at least one of them was 9-zip against the EPA, including Obama's own appointees, and it was during Obama. Might have been, I really should know. I think it was Sackett versus EPA 2009. That's what came out of my, but that was a water rights case. Okay. Now, um, that was okay. I'm not going to get into that. I'm just putting this on your radar. Sackett versus EPA. A lot of ink has been spilt about that, and it needs to be on your radar. It needs to be on your radar. Okay, page 69 at the top. While we're talking about riparian rights, okay. In one sense, Kaiser Aetna is unique because it concerns the entitlement it was over which was in its inception within the exclusive possession and control of a single individual. Most cases involving water rights are more difficult because the question is who has what entitlement with respect to, say, a river, which in any view is held by many persons in common. The precise nature of the competing claims in water is often difficult to determine because of the persistent tension between three separate theories of water rights: the natural flow theory, the reasonable use theory, and the prior appropriation theory. The differences among theories, however, have been suppressed in the decided cases as the paramount navigation servitude has swept everything aside. That's very good. He knows Roman riparian right stuff and the civil law stuff, the common law stuff. He was educated in England. I think he got his LM there, LLM. Well, is that the degree? He did some work at Oxford, I believe, in this stuff. So it's very interesting. Okay. Uh, John Hughes always giving him a hard time about talking about Roman riparian rights, but he doesn't really talk about it on that podcast very often, the Law Talk podcast, so I don't know what John's talking about. Page 69, continuing. Even on a sounder view, the differences among these theories are rarely material. The competing theories of property rights and water are chiefly addressed to the rights as between riparians to divert water for their own use. No theory ever allowed private owners to block or hinder navigation on public waters. The central source of litigation in the eminent domain case has been quite the opposite. Um, to what extent can the government rely on its navigation servitude in order to abridge upon private rights, not only of diversion, but also of access and use? In the contrast to cases like Kaiser Etna, one can assume that some easement for the benefit of the public at large does exist, whether by long-standing custom or by some more overtly utilitarian view. The question, therefore, within both the private law and the eminent domain context is, what is the scope of the navigation easement so created? Yeah, that's very good. Man, that is so precise. He just nailed it. Yeah. What is the scope of the navigation easement so created? Here, it is instructive to revert to a traditional maxim of water law: aqua curat qua aqua curere debet. Water ought to flow where it in fact flows. So it looks like he likes the natural flow theory. Very good. Gosh, I need to do a deep dive into water rights. This is so fascinating. An approach of this sort appears to leap in a single bound the enormous chasm between is and ought, and to embrace a teleological view of inanimate objects, not to mention ecological systems, that is quite out of character with today's tempered skepticism. Very good. But there is, in fact, good reason to recognize the practical strengths of the maxim, even if it does not capture an ultimate truth. So he'll always punt to utilitarianism as kind of a backup plan, which I don't really like, but I guess he's just kind of appealing to people's practical sense, common sense, practicality kind of thing. So we're on page 70 at the top. That the rule bridges the gap between is and ought is hardly a demerit, for every rule of entitlement so functions. Better there be a connection between is and ought than no connection between ought and anything of interest in the external world. For dealing with the eminent domain clause, it is surely, don't call me Shirley. Don't call me Shirley, Richard. It is surely preferable to recognize a system of rights already in place than to invent one to replace it. Now, that's definitely his preference. Okay, let's look at the footnotes on page 39 at the bottom. Okay, footnote 20, I'm going to read. The first of these two theories are riparian in the sense that ownership of the land carries some interest in the water that passes through it. The theories differ concerning the amount of water that any riparian can withdraw for profitable use. Only minor diversions for domestic purposes are permitted on the natural flow theory, while greater diversions for agricultural and manufacturing with some harmed neighbors are permitted under a reasonable use theory. So the reasonable use theory is the most biased toward the government. That's what gives the government the greatest latitude to win when they're sued. So it matters quite a lot which theory is true, right? Which theory is true? The prior appropriation theory works on a different ground. The ownership of future water flow is acquired by appropriation of the flow and is not a necessary consequence of ownership of the banks. Each of these theories contains enormous internal complexities, which are admirably set out in Joseph Sachs' Water Law, Planning and Policy, 1968. That looks like it's a short law review article. For an exploration of the economic weaknesses of the three systems, see Mason Gaffney, Economic Aspects of Water Resource Policy, 1969. And then he says, for my views, see Richard A. Epstein, Why Restrain Alienation, in the Columbia Law Review. And can that possibly be true? What page numbers, Richard? Richard, did you proofread this? Harvard University Law. Did you proofread this? Footnote 20 on page 69. Hello? Hello? You want to see what I'm looking at with this page number? You want to see what it looks like for me? Found another mistake in Harvard Law, Harvard University Press. Come on. Come on, Zoom. Play along. You see that? Look at that page number at the bottom. 000, comma 000. You see that at the bottom? Zeros. The page number is 000 and comma 000. Okay, Harvard. Gosh, you'd think that they would have fixed that by now. I mean, they are Harvard University Press, which is attached to, what school is that attached to? I think it's Bunker Hill Community College. I think that's where it's attached. Now, let's continue here. Let us continue, not to bring up health food. Righty, where are we at? Where did I leave off? Okay, yeah. Page 70. The parallels between water law and the first possession rule with respect to land are instructive. Yeah, buddy. See, okay, so he's using the riparian analogy to get at taking prima facie possession and use on land. One hidden strength of the rule. Now, let me just add something really quick. Sorry, about water law and about riparian law. Riparian law, water law is much more complicated than land stuff. And it's related to land stuff because water is defined in relation to land. The reason he thinks you should dip into the riparian analogy and figure out, roll up your sleeves, do the hard work, do the heavy lifting, figure out which of those theories is true. Okay. Because that, if you do the heavy lifting there, it's you're going to sort out so much junk when it comes to land. You're going to see it clearly. You're going to see it a lot more clearly. I think that's what he's saying here. And I think that's right. That picking the right analogy is really important in figuring out how to proceed so you don't go crazy. But then how do you know which an analogy is the right one? Well, welcome to the party here. That's what we're trying to figure out. Now, the parallels between water law and the first possession rule with respect to land are instructive. One hidden strength of the rule is that it gives a baseline for analysis that provides a clear foundation for future voluntary transactions and is largely impervious to political manipulation. Sounds great to me. The relative clarity and certainty that come out of this rule will apply to all types of waterways, letting us avoid the temptation to tailor ad hoc rules once a dispute arises. Do you think that people have always been tempted to tailor ad hoc rules once a dispute arises? Yeah, of course. The dispute arises and you're trying to figure out how you're going to win this dispute. So you try to game the rules to, and to give you the win. But the rules are ad hoc because the rules didn't exist when this dispute arose. The rules that you're talking about trying to apply. Now, using the natural condition of the water as a baseline of entitlements means that no individual is charged with the affirmative duty of changing the situation for the benefit of others. By the same token, no individual may change the flow in ways that prevent others from using or gaining access to the waters in question. By our own major premise, the state is still in no better position than the public it represents. This view solidifies the status quo ante, but it does not create any partisan advantages between persons or between the government and persons, for all rights and duties run in both directions. Nor does it prevent state coerced changes that satisfy the ordinary requirements of the eminent domain clause. Okay. Judged by these standards, the government can, without compensation, enjoin activities by riparians that reduce the ease of passage along navigable rivers, as much as it can remove blockages, piers, dams, mills, or whatever placed along public waterways. But by the same token, it cannot cut off use of or access to waters in their original condition unless prima facie it is prepared to compensate those individuals whose rights it has taken. To be sure, this watery baseline leaves some unavoidable gray area that is avoided by recognizing complete and paramount rights in the government. Yeah, yep, that's right. It is, for example, unclear whether government action to prevent the deterioration of waterways under normal conditions requires compensation or, on the ground, that the routine maintenance is only a succession of small permanent improvements. Okay, all right, sounds good. Yet the Supreme Court has missed the easy cases, not the hard ones. That is devastating criticism there. And if what he's saying is correct, yeah, it follows. And I think he is correct, except for when he punts to utilitarianism. But I understand when he does that. It's practical. He's trying to deal with these skeptics, these materialists, these atheists, these ne'er-do-wells on his faculty. Yet the Supreme Court has missed the easy cases, not the hard ones. Page 71 at the top. One unfortunate line of cases concerns the use of water for power generation, which is made possible when water falls from a higher to a lower level. In keeping with the general theory here, any riparian should be able, so long as he does not interfere with the pre-existing flow of water, to take advantage of the height differential to generate power for his own use and benefit. Indeed, in the private context, creating obstacles along the river that remove or limit the height differential are actionable wrongs, remediable with damages and injunctions. The public parallel arises when the government has built dams or completed other water reclamation projects that have backed up tailwaters to the level of headwaters. In the first of these major cases, United States versus Chandler Dunbar Water Power Company, and that is 1913, the Supreme Court held that the government was not required to pay compensation when it raised the levels of water in a navigable river and thereby rendered inoperable the claimant's power plant that was located on the navigable portion of the river. The case seems clearly wrong. There Richard goes again. Boom, right after the court when it screws up. The case seems clearly wrong because the government did not seek only to protect the rights in flow it already enjoyed, but to expand them beyond their natural contours. Very good. Chandler Dunbar was distinguished in the United States versus Kress, which was 1917, which ordered compensation when the government raised the level of water on a navigable river to the mean high water mark, thus interfering with a mill on a non-navigable portion of the river. The third case was Willow River Power, where the court did not trouble itself to say whether the plaintiff's plant was located on navigable or non-navigable waters. It seemed that the plant was located by the junction of two rivers, which with part of the tailwaters in navigable waters and part in non-navigable. You see how complicated this can get? Brushing the details aside, the court in Willow River Power, and that the date on that is 1945, held that as precedent Kress, that's the 1917 case, right? Let me just double check. Yeah, 1917, must be confined to the facts there disclosed. Oh, that's a trick. That's a trick. Do you see that? That's a trick. Richard caught him. Again, any independent account of water rights condemns this decision as erroneous. Wow. Very good. Now, what you're seeing here is an invitation to get into riparian law if and when you ever have the energy, because you will not be disappointed. You need to have a good guide, though, to Mark Twain. Now, lest it be thought that these decisions rest upon some special mystery associated with power generation, the navigation servitude has been applied in decided cases to destroy, rather, whether by flooding or specific government order for removal or alteration, perfectly ordinary property rights or property interests, such as improvements constructed between the high and low watermarks. We're on the bottom, page 71. The decisions powerfully illustrate the unacceptable tendency, page 72 at the top, tendency to create two sets of property rules in eminent domain cases, one for ordinary people and one that yields unprincipled advantages to the government. Another fantastic line by this master scholar. The decisions powerfully illustrate the unacceptable tendency to create two sets of property rules in eminent domain cases, one for ordinary people and one that yields unprincipled advantages to the government. See, this is basic due process because it's the government that's deciding the case, right? Well, if you start with the rule, if the government, which is the government judge, starts with a rule that yields an unprincipled advantage to the government, well, then that's not a neutral party to the case. And you're entitled by due process to a neutral third party. You see what Richard's getting at? Let me just restate something he said on page 68. The government is not ipso facto vested with any rights at all. Let me just restate it in context. Once this elementary confusion, page 68, of jurisdiction with entitlement is exposed, how then are initial entitlements determined? Here, the central insight is that which organizes the entire discussion of prima facie takings. The government is not vested ipso facto with any rights at all. That's the background here of what he's saying here. And I'm going to read page 71 to 72 again. These decisions, these riparian decisions, remember, he says on the bottom, page 70, the Supreme Court has missed the easy cases, not the hard ones. Now, if you screw up the easy ones, you're going to screw up the hard ones too. Page 71 at the bottom. The decisions powerfully illustrate the unacceptable tendency to create two sets of property rules in eminent domain cases, one for ordinary people and one that yields unprincipled advantages to the government. Page 72 at the top continued. The story is similar for those cases which involve access from the shore to navigable waters. Here, it is well established in private law that the individual riparians cannot be denied access across their lands to flowing waters, whether navigable or not. Any blocking or impeding of access by private property, whether or not a riparian becomes actionable by the owner, even if he cannot obtain access to the river from other points. Sorry, even if he can obtain access to the river from other points open to the general public. Okay. These results are no different from those which allow an owner abutting on the highway and action against a third party who blocks his access to the road. Given the constant metaphor of the navigable river as a water highway, the same principles should be applied against the government. But a uniform line of cases starting with Scranton versus Wheeler have reached the opposite conclusion that all access rights, total and partial, including the worth of riparian land as a port site, are subordinate to the navigation easement. The decisions are so clearly wrong under any sensible view of the original entitlements between riparians on the one hand and public at large represented by the government on the other that they require no further comment. I'm going to get a drink of water. I'm going to mute it just for a sec. Thanks for waiting. All right. Yeah, good. So this riparian analogy with roads and just, land is very important, very important. And I hope you're seeing this, that just because someone has authority or some court has authority to make a decision that's binding in a particular case does not ipso facto mean that they got the right answer. And you guys, you should know that. Any mature person should know that. Okay? There's no magic formula for appointing the right people to an authoritative body and getting the right answer. That's just not how this works. You have to be able to think for yourself. You got to grow up, dude. You got to grow up, and it's hard. It's really hard. But that's what we're doing here. Trying to get you to grow up to the best of your ability. At least try. Just try, you know? All right. It does not follow, however, that the compensation should be awarded in all navigation easement cases, given the defensive rights in the public at large. Thus, United States versus Rio Grande Dam and Irrigation Company. The United States versus Rio Grande Dam and Irrigation Company was 1899. Upheld all these cases are AD, not BC, FYI. the upheld the power of the United States to enjoin construction of an irrigation project not on the river that threatened the river itself. This case, unlike all the others considered, is correct. Okay, pay attention to that. If Richard says it was correct, you want to, that's a kind of a baseline. Hang on, you can hang on to that bar, in the wind, and trying to figure out what he's saying, what he's talking about. Because here it was the government, not the private party, who sought to respect the status quo ante, which delineates the original rights. As with the land-based cases, the principle which begins from natural conditions can be applied neutrally in ways that the bare assertion of a paramount state interest cannot. That's great. What a way to end the chapter. Possession and use in the section called Takings Prima Facie in this brilliant book, Takings, Private Property and the Power of Eminent Domain by Richard A. Epstein, Harvard University Press. I'm going to read that last section there again. This case, unlike all the others, is correct. Which case again was that? United States versus Rio Grande Dam and Irrigation Company, 1899. You want to look it up? It's 174 in the U.S. reports, starting at page 690. 1899 AD, not BC. And he says, upheld upheld the power of the United States to enjoin construction of an irrigation project not on the river that threatened the river itself. This case, unlike all the others considered, is correct because here it was the government, not the private party, who sought to respect the status quo ante, which delineates the original rights. As with land-based cases, the principle which begins from natural conditions can be applied neutrally in ways that the bare assertion of a paramount state interest cannot. Well, I originally read this on Sunday, 18 June 2022, years after Jesus. Wow, that was almost 4 years ago, 7:55 p.m. in the backyard with a Faustinian cigar bought in the Dallas area. And apparently that was sent by Curtis late May 2022. Remember Curtis? Curtis Olson, um, valued friend, and someone I couldn't have started the podcast without. He was my co-host for a while. In his family obligations, uh, took more of his time and energy than he had to continue as co-host. Um, so, but anyway, Curtis Olson, buddy, I got you in here as mentioned for you sending me those cigars. I don't know if you remember that or not. I appreciated it. Now, this this book was sent by, it's a gift to the podcast by, I believe it was Blair Rippey, who I went to high school with. Blair, do you remember sending this? You probably don't remember. Um, I had it in here. I had the note in here. It's probably still in here somewhere. I usually keep pretty good records in case I want to go back and thank somebody for what they did. Let's see. Well, I'll figure it out. I'll figure it out, man. I believe it was Blair. I don't know why I believe that. Where's the documentation? Crud, dude. I'm almost certain it was Blair. Blair Rippey, I believe. Well, anyway, I should have made a note in the book. Huh. You know what? I think what happened was she sent me an Amazon card, and then I used that to purchase it myself, which is why I didn't keep the receipt because I purchased it myself with her card though. And I think she sent it to me in such a way that it was kind of incognito. because I don't think she wanted me to include her publicly, which I just did. Sorry, Blair. Blair's one of the few people I actually keep in contact from high school somewhat and have good, warm memories of her. She's got a PhD from the University of Kent in chemistry or something. She's a scientist. Well, anyway, I enjoyed this time with you. Let's have a chaplain's corner. We're going the next one. You guys, if you're wondering how I choose these psalms, I'm just going down the list here, the CBS list from this past year. We did community Bible studies, a men's Bible study on Tuesday nights. And the next one is, well, I did 59, so we're doing 60 today. See? That's how I choose. So we're doing Psalm 60 and we're doing Streams in the Desert, January 30th. Let's do Psalm 60. We're going to do the King James Version again. O God, thou hast cast us off, thou hast scattered us, thou hast been displeased. O turn thyself to us again. Thou hast made the earth to tremble, thou hast broken it. Heal the breaches thereof, for it shaketh. Thou hast shewed thy people hard things. Thou hast made us to drink the wine of astonishment. Thou hast given a banner to them that fear thee, that it may be displayed because of the truth. Selah. Verse 5, Psalm 60, King James Version. That thy beloved may be delivered, save with thy right hand and hear me. God hath spoken in his holiness, and I will rejoice. I will divide Shechem and mete out the valley of Succoth. Succoth. Verse 7, Gilead is mine, and Manasseh is mine. Ephraim also is the strength of mine hand. Judah is my lawgiver. Moab is my washpot. Over Edom will I cast out my shoe. Philistia, triumph thou because of me. Who will bring me into the strong city? Who will lead me into Edom? Hmm. Wilt not thou, O God, which hast cast us off, and thou, O God, which didst not go out with our armies? Page 11, sorry, page 11, verse 11, Psalm 60, King James Version. Give us help from trouble, for vain is the help of man. Amen. Amen, bro. Verse 12, and this is the final verse of Psalm 60, King James Version. Through God we shall do valiantly, for he it is that shall tread down our enemies. Psalm 60, King James Version, a moment of reflection. Okay, now we have a reading from Streams in the Desert, January 20. We did January 29th last time. The time before that, we did January 28th. We're just working our way all the way through this book. January 30th. Here we go. I will be as the dew unto Israel. Hosea 14:5. The dew is a source of freshness. It is nature's provision for renewing the face of the earth. Oh, I love that. It falls at night, and without it, the vegetation would die. It is this great value of the dew which is so often recognized in the scriptures. It is used as the symbol of spiritual refreshing. Just as nature is bathed in dew, so the Lord renews his people. In Titus 3:5, the same thought of spiritual refreshing is connected with the ministry of the Holy Ghost, renewing of the Holy Ghost. Many Christian workers do not recognize the importance of the heavenly dew in their lives, and as a result, they lack freshness and vigor. Their spirits are drooping for lack of dew. Beloved fellow worker, you recognize the folly of a laboring man attempting to do his day's work without eating. Do you recognize the folly of a servant of God attempting to minister without eating of the daily manna? Nor will it suffice to have spiritual nourishment occasionally. Every day, you must receive the renewing of the Holy Ghost. We're on page 34 at the top. You know, when your whole being is pulsating with the vigor and freshness of divine life, and when you feel jaded and worn, quietness and absorption bring the dew. At night, when the leaf and blade are still, the vegetation pores are open to receive the refreshing and invigorating bath. So spiritual dew comes from quiet lingering in the Master's presence. Get still before him. Haste will prevent your receiving the dew. Wait before God until you feel saturated with his presence. Then go forth to your next duty with the conscious freshness and vigor of Christ. Dew will never gather while there is either heat or wind. The temperature must fall and the wind cease and the air come to a point of coolness and rest, absolute rest, so to speak. Absolute rest, so to speak, before it can yield up its invisible particles of moisture to bedew either herb or flower. It's the first time I've ever seen that verb bedew. Bedeew. That's a good verb. I like that one. So the grace of God does not come forth to rest the souls of man until the still point is fairly and fully reached. Quote, drop thy still dews of quietness till all our striving cease. Take from our souls the strain and stress, and let our ordered lives confess the beauty of thy peace. Breathe through the pulses of desire thy coolness and thy balm. Let sense be dumb, its beats expire. Speak through the earthquake, wind, and fire, O still small voice of calm. A moment of reflection. January 30th, streams in the desert. This is the original non-woke edition. Post Office Box 9812, Lost Feliz Station, Los Angeles, California. published in 1925. The newer editions substitute some wording and you lose something important, I think. So I like this edition right here. I really like it. All right, guys. Thanks for joining me on the Republican Professor podcast. I've been your host, Dr. Lucas J. Mather. Today is 22 May, 2026 years after Jesus, and we did TRP. Come on, guys. Come on, pencil. TRP episode 22 May 2026, Friday. And that was EP number 11. And let me just put that in the front here. Just helps me keep calm and collected. I can pick up this book and remember. It's a good habit to get. 22 May 2026. It's a Friday. And this is episode 11. Okay, good. Now, can I just say one thing?
You've been saying a whole crap load of stuff.
All right, thanks. But I'm just going to say the next chapter is the rights of disposition and contract. Okay, that's going to be fun. Okay, now, leaving this aside, there's a new topic we're going to be talking about on the podcast, which is Marxism. We've covered it here and there, but it's this book by Thomas Sowell called Philosophy and Economics, Marxism, Philosophy and Economics. This is published by Quill Press, Madison Avenue, New York. And it's, man, I'm telling you, that we really do need to get into this Marxism. I've had this book for a long time. I cannot actually I remember when I first got it. I think I got it in high school, and I think I bought it at Barnes and Noble. 1985, Thomas Sowell. And where did I don't have, that was before I was really keeping receipts and stuff like that. I was just a kid, man. Sometimes I accidentally see a receipt. Like I have Will Durant's set that Barnes and Noble was selling back in the 90s. I bought it with my paper route money, and one of those volumes has the receipt in it. And I was like, I knew about it at Barnes and Noble, and it's got the 1993. And I had those volumes with me the entire set all through my Navy career. The table of contents is economics and philosophy, the dialectic approach, philosophic materialism, Marxian theory of history, capitalist economy, Marxian economic crisis, Marxian value, political systems and revolution, Marx the man, the legacy of Marx. Excellent stuff. Thomas Sowell, Marxism, philosophy and economics. We're starting that this year on the podcast. Thanks for joining me on the Republican Professor podcast. I've been your host, Dr. Lucas J. Mather. It's a Friday, 22 May 2026, years after Jesus, AD. God bless you guys. See you next time.